Now we'll discuss regarding HIBA or gift as under Islamic law. So the very meaning and definition of HIBA under Islamic law. So in Muslim law, gifts are called HIBA. The English term gift is of a wider connotation and applies to all transactions where one transfers one property to another without any consideration. The term hiba has a narrow meaning according to Dar ul Muta. Hiba is a transfer of the right of property to another without return, and according to Ameer Ali, a HIBA is a voluntary gift without consideration of property or the substance of thing by one person to another so as to constitute the donee the proprietor of the subject matter of the gift, and according to the Hanafis laws, define hiba as an act of bounties by which a right of property is conferred in something specific without as any exchange. And among the Shias, HIBA is an obligation by which property in a specific object is transferred immediately and unconditionally without any exchange and free from any pious or religious purpose on the part of the donor. So Muslim law allows a Muslim to give away his entire property by a gift, but intervenes even with the specific object of disinheriting the legal heirs. And now we'll found how the question hiva is differs from sadak, and as sadak practically in all essentials the hiba and sadak are similar. What distinguishes them from each other is their objective. So when a person makes a gift of some property with the object of acquiring some religious or spiritual benefit or merit, it is called sadaq. Just as in hiba, so in sadaq, the gift is not valid unless accompanied by the delivery of possession, as it was found in Hidayah, the ancient and oldest source of Islamic law, and as it was quoted by Professor Bali. So the sadaq is to be distinguished also from waqf, and waqf, both sadaq and waqf are made with an object of acquiring religious merit or spiritual benefit. When the subject matter of the gift is to be accompanied and consumed, it is sadaq. When the very purpose is made unconsumable and only the income is to be used for the purpose, then the transaction is called waqf, as it was held in the leading case Ghulam versus Sultan in 1967 by the Odisha High Court. And in the same way, when a waqf deed makes the subject matter of waqf unalienable An alienation made up the property is also void. It was also held in the leading case, Mumtaz Ali versus Ali in 1968 by the Odisha High Court. So, also Bali quoted from Hidayah, according to Abu Yusuf and Muhammad, a waqf signifies the extinction of transfers ownership in the thing dedicated and the detention of the thing or property in the implied ownership of God, and in such a manner that its profit are applied for the benefit of mankind, as it was mentioned in Hidayah, the ancient and oldest source of Islamic law, and as it was quoted by Bali.